Hi, I'm David Fraser. I'm an internet and privacy lawyer in Canada with the law firm McGinnis Cooper. Today I'm planning to talk about the privacy torts in Canada, which are the theories of law under which an individual can sue or be sued for invasion of privacy. This is something that's been under significant transformation, and one can say was dramatically revolutionized in 2012 with a groundbreaking decision that I'll talk about in this episode. So I'm going to talk about what the state of play was before 2012, some of the privacy torts where individual provinces have created a statutory ability to sue for invasion of privacy. I'm going to talk about the groundbreaking decision in Jones and Tsige from the Ontario Court of Appeal and the torts that gave birth to, intrusion upon seclusion and the public disclosure of private facts. And then I'm also going to talk about the tort of breach of confidence, which is one that has evolved beyond the commercial context into dealing with invasions of privacy as well. So the state of the law in Canada before 2012 was that there were really limited remedies for invasion of privacy in what we usually think of as being kind of Canadian privacy laws. The Personal Information Protection and Electronic Documents Act, which is the federal commercial privacy law. We also have the provincial general commercial privacy laws in British Columbia, Alberta, and Quebec that really don't have in themselves significant remedial powers, no private right of action in the way that lawyers normally talk about it, although there was the opportunity for redress in the courts. Public sector privacy laws, in fact, have very few remedies where an individual can seek compensation or damages where their privacy has been invaded. But until 2012, there really was no common law remedy for invasion of privacy. That's where you could go to court and the court would be able to adjudicate the facts and award an individual compensation for their privacy having been invaded upon. But as I said, some provinces have statutory torts, and they still do. But until 2012 in the rest of Canada, there really was no remedy for privacy claims. Sometimes privacy claims were accompanied by arguments related to eavesdropping or arguments related to trespass, and they might have had some limited success there, but not a general recognition that an individual has a right to privacy and has a right to claim compensation where that's been invaded upon. Now, not surprisingly, Quebec has been at the forefront of privacy in Canada, and its civil code traditions have included privacy rights within its legal framework. So even just Section 3 of the Quebec Civil Code says every person has privacy rights. It says every person is the holder of personality rights, such as the right to life, the right to the inviolability and integrity of his person, and the right to the respect of his name, reputation, and privacy. These rights are inalienable. And then the Civil Code goes on a little bit further to say at Section 35, every person has a right to the respect of his reputation and privacy. The privacy of a person may not be invaded without the consent of the person or without the invasion being authorized by law. The Civil Code actually goes on and gives us some examples of what would be considered to be invasions of a person's individual privacy: entering or taking anything in his dwelling, intentionally intercepting or using his private communications, appropriating or using his image or likeness while he is in private premises, keeping his private life under observation by any means, using his name, image, likeness, or voice for a purpose other than the legitimate information of the public, and using his correspondence, manuscripts, and other personal documents. You know, and for those who follow privacy and privacy torts and their evolution in Canada, you're probably familiar with a case, Edition Vice Versa, where an individual was able to sue a publication for a photograph that was taken of the individual in public that was then included in the magazine, on the cover of the magazine, I believe, went all the way up to the Supreme Court of Canada and recognized that that individual was entitled to compensation, even though they were in a public place. And so Quebec civil protection of privacy rights has been strong and robust for some time. Likewise, in some other provinces, in some common law provinces, have had statutory torts for invasion of privacy. These provinces include British Columbia, Saskatchewan, Manitoba, and Newfoundland and Labrador. Now, there has been some uncertainty of whether the new common law claims that I'm going to talk about fully displace these statutory torts. But these have been around for some time and interestingly have not been used that much, which the reason for that may simply be that we are way more sensitive now to privacy rights and privacy claims. And it may be that the evolution of technology has meant that individuals, their privacy is perhaps a greater risk, or they're just much more aware of the rights and remedies that they might have. So let's just take a look at the British Columbia Privacy Act. And so it says it creates a tort. That's your ability to go to court and sue somebody for an invasion of your right. It is a tort actionable without proof of damage for a person willfully and without a claim of right to violate the privacy of another. So it means you don't actually have to show harm to your personal interests or otherwise to be successful in a claim. It also means that the person who you're suing or who is being sued has to have done what they did willfully. They have to have done it on purpose. Kind of takes away the possibility for one to be careless or to just accidentally invade somebody else's privacy. And then it says, look, when we're looking at what is a privacy interest, paragraph 2 there says, the nature and degree of privacy to which a person is entitled in a situation or in relation to a matter is that which is reasonable in the circumstances, giving due regard to the lawful interests of others. So whether or not somebody has an entitlement to privacy, has an expectation of privacy, is going to have to be looked at in terms of what is reasonable in those particular circumstances. And you also have to look at what are the legitimate and lawful interests of others that are concerned. It then says, in determining whether the act or conduct of a person is a violation of another's privacy, regard must be given to the nature, incidence, and occasion of the act or conduct, and any domestic or other relationships between the parties. And so you don't have necessarily kind of a hard and fast list of where you have an expectation of privacy or where you don't, what is an invasion of privacy or what is not. It requires looking at it through the lens of what's reasonable in the circumstances and also how are others affected. There are some significant exceptions to what would otherwise potentially be an invasion of privacy. The first one is consent, which is relatively obvious. If you consented to provide your information to another in particular circumstances and the information was used in the way that you expected, it's very hard for you to say that your privacy was truly invaded and you should be entitled to damages. It also has an exception for where the invasion is incidental to lawful right of defense of person or property, where it's authorized by law, where it's done by cops or law enforcement in the course of their lawful duties, and also takes into account freedom of expression interests for publications where it is in the public interest or where it relates to a comment on a matter of public interest. And so those provinces that do have the statutory tort under their privacy acts, they're all generally pretty similar. And as I said, they haven't been used all that much to date. But the privacy landscape, at least in the common law, was significantly altered in 2012 with a case from the Ontario Court of Appeal called Jones and Tsige. And this case pretty well kind of blew the doors off private privacy claims in Canada. So the background to this particular decision, you had two bank employees. So they both worked at one of the large Canadian chartered banks. And the defendant's ex-husband was now in a relationship with the plaintiff. And at least as the plaintiff explained it, or at least as the defendant explained it, she was concerned about whether or not child support payments that should have gone to her were in fact going to her colleague who her ex-husband was now dating. So over the course of 4 years, the defendant looked at the personal banking records of the plaintiff at least 174 times. So what we have come to call a kind of a classic snooping case. An individual employee of an organization who had access to information about customers or patients, this often happens arises in the healthcare context, looks at records where there's no real justification for doing so related to the discharge of their duties. Often it's just out of curiosity. And in this case, as it often is the case, all the defendant did was look. She just looked at those records. She didn't blackmail her colleague. She didn't confront her colleague. She didn't confront her ex-husband. All she did was look. And in the course of its ordinary kind of security activities, the bank audits who access whose records and tries to determine whether or not there has been inappropriate access to customer information. And perhaps not surprisingly, 174 times, the bank discovered that the defendant had in fact looked inappropriately at her colleague's banking records. The bank told the plaintiff, told Ms. Jones, and then disciplined the defendant, Ms. Tsige. And that could have been the end of that, but it wasn't. What happened next was Ms. Jones brought a civil claim for privacy infringement against Ms. Tsige, her colleague. And when they got to the Ontario Superior Court, the Ontario Superior Court said, there is no tort of invasion of privacy in Ontario. And that determination was entirely consistent with the jurisprudence from the Ontario courts. The case law had been moving in that direction, but one could not say at that stage that there really was a tort of invasion of privacy in Ontario. And Ms. Jones then appealed to the Ontario Court of Appeal. And that changed everything. In the course of its decision, the Ontario Court of Appeal imported into Canada U.S. privacy torts, what are often called the Prosser privacy torts. Now, two of them we actually already had that had found its way into Canadian common law. Kind of appropriation of personality. So that's when you use somebody's likeness or their personality for commercial gain. And false light publicity, which at least in Canada has largely been rolled into defamation. So we had two torts left that had not been formally recognized in the Canadian common law. The first one being intrusion upon seclusion, and the second being public disclosure of private facts. And we'll see how these have found their way into the common law, but also how the tort is made out. So the Court of Appeal said that, and I think this is accurate, when you look at the grand sweep of the case law, there had not yet been a recognition of a cause of action, an ability to sue for invasion of privacy in the common law in Canada, but the case law was certainly moving in that direction. And so the Ontario Court of Appeal said this is an incremental step that's consistent with the role of this court to develop the common law in a manner that is consistent with the changing needs of society. So this was rooted in the adoption of technology, the fact that there perhaps are greater privacy risks all over the place, greater recognition of privacy within the charter when it comes to an individual's right vis-a-vis the state. And the court said and noted, charter jurisprudence recognizes privacy as a fundamental value in our law and specifically identifies it as worthy of protection, a right to informational privacy that's distinct from personal and territorial privacy. The court then goes on and says, and this is the connection to technology, the internet and digital technology have brought an enormous change in the way that we communicate and in our capacity to capture, store, and retrieve information. As the fact of this case indicate, routinely kept electronic databases render our most personal financial information vulnerable. And so what was brought in was this intrusion upon seclusion tort. And the court elaborated in paragraph 71 of its decision the key features of a claim for intrusion upon seclusion. The court said, first, the defendant's conduct must be intentional, within which I would include reckless. And so the original US tort just required that it be intentional, but the Ontario Court of Appeal expanded it to be a reckless intrusion upon seclusion. So one could do it accidentally, but only if you are reckless in doing so. The court said the second part is the defendant must have invaded, without lawful justification, the plaintiff's private affairs or concerns, which would, of course, require an examination of really, is it somebody's private affairs or somebody's private concerns, and the degree to which they're private. The third part, the court says, was that a reasonable person would regard the invasion as highly offensive, causing distress, humiliation, or anguish. The court said you don't have to prove harm to a recognized economic interest as an element of the cause of action, given the intangible nature of the interest protected. The court said damages for intrusion upon seclusion will ordinarily be measured by a modest conventional sum. And in that case, for general damages, which is the part of legal damages that addresses hurt feelings, upset, distress, humiliation, or anguish, the court said, there's going to be a range from nominal damages to about $20,000. And in the case of Jones and Tsige, the court said that fit in the middle and awarded the plaintiff $10,000 in damages in that particular case. One thing that's interesting is that the defendant in this case had not disclosed to the plaintiff that she had looked at her colleague's banking records. And so it was only at the time that the bank advised Ms. Jones that her records had been looked at that she had the opportunity to know that had happened and to experience that distress, humiliation, or anguish. And so one can be intruded upon and not know it, but the court, that is still compensable. It's not tied to that information being used for blackmail or to have been published or to cause the individual reputational harm in the community. That can be dealt with in the public disclosure private facts tort. But simply the matter of the intrusion, the act of the intrusion into somebody's private affairs or concern in a manner that once discovered would be considered to be highly offensive to a reasonable person. That gives rise to the claim for damages for intrusion upon seclusion. The other tort that was imported, it was imported implicitly in Jones and Tsige, but has been recognized subsequently, is the tort of public disclosure of private facts. And the elements of this cause of action include one who gives publicity to a matter concerning the private life of another is subject to liability to the other for invasion of privacy if the matter publicized or just the act of publication would be highly offensive to a reasonable person and is not of legitimate concern to the public. And so we add on a couple things here. It gives publicity, so it has to be made publicly known or at least widely known. Kind of gossip to one or two people is not going to cover it. Again, similar to intrusion upon seclusion, it has to be highly offensive to a reasonable person. But notable, it includes is not of legitimate concern to the public, taking into account that certain disclosures of private facts could be of legitimate concern to the public. So recognizing freedom of expression and freedom of the press when it comes to disseminating information about somebody's private life, but where it is, in fact, of legitimate concern to the public. So this tort was recognized in an Ontario case called Doe and ND, 2016 decision from the Ontario Superior Court, which is an incredibly disturbing case of image-based abuse. And so in this particular case, a sexual video was published by the defendant online and disseminated to some of his friends, causing significant anguish and significant psychological harm to the plaintiff. And the plaintiff sued and also included claims for breach of confidence that I'll talk about in just a moment, and was successful on summary judgment. And the court recognized, and I think was very sensitive to, the dramatic betrayal that this represented and the significant harm that it caused to the plaintiff in that particular case. And so I don't think there's a whole lot of doubt that, at least in common law Canada, intrusion upon seclusion and public disclosure of private facts are new legal theories that can be relied upon to advance a legal claim for damages for a breach of privacy. Now we have a final cause of action that we're going to talk about, which is one that's been around for quite some time, but has generally been used to deal with kind of commercial, confidential information. And the elements of this cause of action are as if the plaintiff has supplied the defendant with information that has a quality of confidence about it. So was it provided confidentially? Was it provided in an intimate circumstance? Was it provided where you would expect that that information would be kept private and personal? And was it done in circumstances in which that obligation of confidence arose? So was it to an intimate partner or to a really good friend or to a physician on one hand, or was it to a reporter on the other? And then the third element is the defendant has to misuse or make unauthorized use of that information. And if those three things are satisfied, and there's no defense of consent, for example, then an individual can claim breach of confidence and can recover damages for that. Now, as I said, it has mostly been used in the context of commercially confidential business information, but it really is a natural extension to include sensitive personal information in that category. And it should also be noted it's an equitable claim. So courts generally have very wide latitude to do justice. And so in fact, the plaintiff in Doe and ND, pleading public disclosure of private facts and breach of confidence, was able to recover damages, or get an award of damages at least, that was significantly higher than the $20,000 kind of guideposts for intrusion upon seclusion that the court had fashioned in the Jones and Tsige case. So we have seen a dramatic transformation in the common law of privacy in Canada since 2012. And we've also seen an explosion of class actions as a result of this. Not many, in fact, almost none have actually gone to trial. But when you hear about a privacy breach of any consequence in Canada, it usually will be accompanied by a class action lawsuit, many of which naming these privacy claims as part of their statement of claim. We've also seen significant snooping cases, many of which resulted in class actions that have been settled, where an individual employee has snooped at records that they had access to, similar to the fact pattern in Jones and Tsige. So this is an area of kind of significant evolution, and we're likely to see even more happening in the next little while. And it will be interesting to see whether or not the update to our federal commercial privacy law is going to include a private right of action that could displace these common law torts. But that remains to be seen. Anyways, thank you. I hope you found this to be interesting and educational. It was not intended to be legal advice. And so if you're dealing with a situation yourself where some of these issues could come into play, you're going to want to reach out to a lawyer who has experience in this area. Thanks again. We'll see you next time.